finding your way to the satellite location of the CPDP. We're very happy to be here with you. And yeah, the panel this morning is gonna be about GDPR and SMEs. The panel topic is actually the GDPR is easy. I personally would have put a question mark there. It's not there, but I think during the discussion we will probably see that there are some questions when it comes to whether or not the GDPR is easy for SMEs. Also in the GDPR itself, it's recognized that public authorities should include specific measures directed towards SMEs. And on this panel we have experts and researchers from, some of them have been involved in 2 EU-funded projects that were actually investigating and trying to help SMEs be compliant with the GDPR. So one is the Smooth project, which assists microenterprises to adopt and be compliant with the GDPR. The other one is the STARII project, which seeks to assist data protection authorities in raising awareness among SMEs about GDPR. So we're going to have some interesting insights from those two projects. And yeah, just to set the ground to this discussion. So, I mean, most of us know that, or we probably, all of us here in the room would know that SMEs are the backbone of the European economy. There are 22 million SMEs in the EU, and they form the core of EU enterprise policy. At the same time, they face challenges from data protection law, and they can often not afford professional legal advice. And some of the findings from the STAR project actually found that the GDPR could be seen by SMEs just as something that adds to the wider set of compliance requirements, so what they have to comply with in terms of taxation, accounting, health and safety, which are generally important and obligations, but that don't really contribute to their core business activity and to generating value. So in this discussion, we would like to tackle these issues. We would like to look at what are actually the distinct GDPR-related needs of SMEs, and what kind of assistance could DPAs, so data protection authorities in the different member states, give to SMEs, and if there are any solutions that are not perhaps in the law, but maybe more technical, that could actually help SMEs comply with GDPR. So yeah, I would like to quickly present the speakers and presenters of this panel. So I'm here with Karen Clemens, who is representing the European Small Business Alliance, and she will be the first speaker in this panel. She's going to set the ground for the discussion, provide some information about the general GDPR hurdles and barriers for SMEs, and also look in some of the solutions that are there. The second speaker is Ms. Tal Taylor from Triliteral Research, here next to my right, sorry. She's going to present an SME hotline experience from the Hungarian DPA. And then we have Jean Attakol from Park Legal. She's going to focus more on the legislative side of GDPR. And then, yeah, the only gentleman on the panel, Nassau, will be speaking about an example of a technical solution. So, yeah, I would like to give the floor to Karen.
Thank you very much, Annika, and it's lovely to be here. And on a nearly all-women panel. No disrespect to Nassau, of course. I'll just get into my presentation, hopefully. Sorry, Annika, could you just remind me where it is? Where do I click through? Okay. Fantastic. Okay, so that's me trying to deal with GDPR and every other SME manager, owner, because I can tell you right now that GDPR is not easy. So I am, my name's Karen, as Annika's told you. I'm representing the European Small Business Alliance, which is the independent voice for European entrepreneurs, representing around 1 million micro and small businesses across Europe. I'm also here as a small micro business manager in my own right, so I come at it from two different perspectives. But primarily we'll be talking about the experience of ESBA members and indeed micros and smalls across Europe. So I would say that overall, SMEs get the point of GDPR. They want their own data protected, and they see the benefit of doing it for their clients, for their stakeholders. From an ESBA perspective, it also contributes to a final objective, I suppose, where data only has value if it has consent attached to it or some protection attached to it. But that's a whole other issue that maybe you'll be discussing during the course of CPDP this year. Some also saw it, as an opportunity to overhaul their IT systems, but to be fair, they were few and far between. I would say also that the legislation was conceived primarily to tackle bad practices of the big players, and we completely understand that the application depends on the nature of the company and the activities, not on the size of the company. But nevertheless, when the actual regulation hit the ground, it felt as though it was disproportionately affecting small micros and smalls. Because as Annika alluded to, small businesses make up the bulk of the European economy. They are the biggest employers, and yet they have the least capacity to deal with new regulations. It's a permanent irony when you're a small business or representing small businesses. They've got smaller budgets than larger corporations, which makes compliance more important. For example, a small business just can't risk getting a fine. We haven't, as far as I'm aware, there's no independent, definitive evaluation yet of how SMEs across the EU and beyond are complying with it and the experience that they've had. So today I'm going to talk to you about anecdotal. I'm going to largely give you anecdotal evidence from our members, from members of other organisations like SME United and Business Europe. Between us, we represent pretty much I would say 90% of the SMEs across Europe. And also I will look at a few studies and surveys that have been done, and they all say the same thing pretty much. So what do they say? There's a widespread eagerness to comply with GDPR on behalf of small businesses, and they have spent a significant amount on consultants and on IT. And sadly, a lot of that money spent on consultants has been misspent because the consultants have given them the wrong advice. It's largely been around the need for systematic consent. If you just put GDPR into your search engine, it will come up almost automatically with some kind of consultancy that's offering you advice for a substantial fee. Basically, they're just completely confused by the sheer complexity of the regulation. And those that think they're compliant aren't always. And there's no way for them currently to test their compliance. So there's a survey carried out by GDPR.eu, which is a Horizon 2020 platform, which showed that 2/3 of individuals claimed that their organisation used an end-to-end encrypted email provider. But when they were asked to specify which provider, only 9% of them could name a service that was relevant, and a lot of them talked about Dropbox, MailChimp, even as a end-to-end encrypted email. So there's a huge amount of ignorance and misunderstanding around their obligations and how to keep data secure. And on top of that, half of them even said that they hadn't determined a lawful basis on which to process user data. So it's wrought with complexities. Yes, sorry, I've already carried that. What then? Why is it so complex? What don't they understand? They're finding it very difficult to determine whether they are a data controller or a data processor. They don't know what it is to mean, what large-scale processing means, because there is no definition in the regulation. They don't know whether they need to be keeping records of processing activities, and this is particularly important because in theory they are exempt from doing so. They don't know that because there's no minimum threshold for when to include a processing activity in the records. They don't know whether they need to appoint a data protection officer, because there's an exemption if they don't process significantly. And there's a great deal of uncertainty around defining the principle of accountability. So as we discussed, there are a few exceptions for SMEs. They're not clear whether they apply or whether they don't, and the exceptions aren't necessarily what they seem because of a lack of clarity definition in the regulation. And not only that, despite the significant efforts by the EC, to be fair, and the European Data Protection Board, the guidance provided by the different data protection authorities in each member state varies vastly from one member state to the other. So although ESBA is a Belgian business and AISBL, we use the Information Commissioner's Office guidance from the UK for our own internal processing because it's so much clearer than anything that the Belgian DPA can provide. Not only that, but there are different interpretations from one DPA to the other. So very recently, the Dutch DPA announced that purely commercial interests and profit maximisation could not be considered as legitimate interests, a legal basis on which to process data, and which completely goes against the recitals of the GDPR, which refers to direct marketing as a valid legitimate interest. So more confusion there again from one member state to another. And very recent, well, also not just that, but Germany has introduced illegally more stringent requirements on the appointment of data protection officers for companies with 20 employees or more. And I know that the Commission obviously is going to take this in hand, but it's always, as you know, a very long, drawn-out process when you try and address this from the Commission to one member state. So in all this uncertainty and complexity, what can we possibly do to ensure that SMEs, A, understand what their obligations are in order to comply with them, and then are able to test that they are compliant? There's an opportunity, potentially, to review the legislation. We probably think on balance it's premature. It's only been around for coming up to 2 years. That said, those introductions of differing standards by Germany, the different interpretations by the Netherlands, cannot continue because all they do is create layers of confusion and an unlevel playing field. So we do need a single set of uniformly enforced data protection rules across Europe because the divergence just costs money and creates confusion. Above all, we need consistent communication and we need tailored information so that a business that is not particularly digitally aware can evaluate what it is they need to do in order to comply. And for that we need a whole series of tools, some of which are in the making, some of which still need to be developed. So within the regulation itself, there are some tools to help businesses. There are standard contractual clauses, which actually are very useful between a data controller and a data processor, and they do make use of those. There are codes of conduct to be drawn up by the trade associations. Those would be incredibly useful as well, because they will be specific to a sector. And there is certification, which has been shown to work in lots of other fields, but it does cost, or it potentially has a cost attached to it, which again is something that a micro business, therefore someone employing fewer than 10 people, would be keen to avoid. But before we even get to that stage, using those tools presupposes a basic understanding of what your obligations are. And I think that actually we need to go back to basics, and we need more consistent information, toolkits that the SMEs can use. Now, there's best practice across the EU. So the French DPA, CNIL, has partnered with BPI France, and they have some extremely useful and tailored guidelines which SMEs can use to determine what they need to do and when. I mentioned the ICO in the UK, extremely useful source of information. They're also actually engaging in a regulatory sandbox to try and work out how to improve, how to keep improving on the information that they provide to SMEs. And then, which I think we'll hear about later, there's a Hungarian hotline which SMEs can ring up to get the information that they need, which is often extremely having a voice, even if it's an automated voice, to talk to can be very reassuring when you're battling with paper and administration. I mean, metaphoric paper, obviously. The Commission has given the data protection authorities, I think, around €3 million since May 2018 to help them reach out to SMEs. It could probably have been better spent. And I would say that the member states probably need to step up and also invest in the guidance that's available to the SMEs. It has to be proven, though, to be successful, so it can only be based on best practice. There are other tools around, and Smooth, which actually Narceo will tell you more about in detail, so I don't want to cover off too much, is a fantastic Horizon 2020 project, which, as Lena said, assists micro-enterprises in adopting and complying with the GDPR, in particular by which is what's being worked on at the moment, by developing a handbook that's widely available, free to use, and designed specifically for micros and smalls. ESBA's very, very proud to be part of this project. There are a couple of challenges ahead. It's getting not necessarily the content right, but the language right, so that it is as accessible to every micro and small across Europe. It is then making sure that there's a proper communication strategy so that SMEs know it's there, because there are all sorts of things on the internet, but they're not necessarily coming to them. So it has to be an integrated package of communication and bespoke information. So I'm going to leave it there. Thank you very much. And I'm going to let Ms. Dahl move on.
All right, good morning, everyone. I'm Ms. Dahl Taylor from Trilateral Research, and I'll be talking about what could be a solution to these SMEs problems that Karen spoke about. And these are solutions that are coming from the data protection authorities themselves, so from the DPAs. And this is based partly on the experience of the STAR2 project, which is also a Horizon 2020 project that looked precisely at these issues. How do DPAs respond and target issues that particularly SMEs might have with implementing the GDPR? And I'll be looking at the experience of the Hungarian Data Protection Authority to illustrate what could help in this instance. So firstly, what actually is an SME? You have to take into account both the staff headcount and either the turnover or the balance sheet total. So medium-sized is fewer than 250 employees, small is fewer than 50, and micro is fewer than 10. So altogether, this comprises a huge range of businesses in the EU. It actually represents 99%, not necessarily 99% of employees or turnover, but of businesses themselves. So there's huge scope for an audience with giving this advice through DPAs. Under the GDPR itself, it does mention SMEs. For example, in recital 13, it talks about the specific needs of these micro, small, and medium-sized enterprises. Article 30 talks about this notion of a record of processing activities. And this is quite interesting because it's been unsure and unclear how exactly SMEs should implement this. Do they or do they not need to keep a record? Because it says it should not apply, or it shall not apply actually, to an organisation employing fewer than 250 persons. So this omits all of the SMEs except for these specific exceptions. So if it's a risk to the rights and freedoms of data subjects, which is huge, because actually arguably data processing in itself could interfere with that right. If it's not occasional, and if it includes special categories of data, so sensitive categories. That article has been a bit of a bone of contention, or lack of clarity. And then Articles 40 and 42, about the specific needs of these companies when they're developing codes of conduct, certification mechanisms, seals, and marks. So the GDPR specifically realises that it's dealing with SMEs. So the overarching obligations, Karen mentioned accountability. You have the principles in the GDPR, but perhaps what are most relevant in terms of obligations upon SMEs are the notions of accountability and transparency. And as you might know, GDPR has enacted new rights for individuals, for data subjects, which now SMEs need to deal with. So, for example, data subject access requests. It's conferred new responsibilities on data processors as opposed to just data controllers. And it's required, in certain cases, businesses to appoint a data protection officer. It's not always clear when exactly they need to be doing this, and certain requirements to train employees in this whole regulation and how to apply it. So data protection authorities have released a lot of information. The ICO, for instance, and you can see a lot of different member state languages there that have issued guidance themselves. They recognise that SMEs have this specific need. Apparently 8 out of 28 DPAs have issued this guidance, so by far not most. And it's that you can also see from the research in the project, but also beyond that, that there's a bit of disparity between SMEs and them realising that they can ask the data protection authorities for guidance when implementing the GDPR. In one of the surveys we conducted, you can see that areas on which SMEs most wanted guidance were organisational measures for data protection and technical measures. So much more than, for instance, the role of the Data Protection Authority. So again, you see this disparity. Now, the Hungarian hotline, this was actually an email hotline. So there was someone actively responding to emails. This happens at all DPAs, of course, and also by telephone, by letter, responding to these queries. But this was specifically the subject of the study. So from March last year to March this year, we've been following the questions that SMEs have raised concerning the interpretation and application of the GDPR. And on the basis of these questions, we'll compile a handbook that can be usable and applicable throughout the EU. So that's the Hungarian DPA's website as it is now. So the first thing you can click on is the hotline. This is to ensure some sort of interaction with SMEs and to encourage them to use it. It's been advertised on the radio and online as well. Okay. And the statistics are that until January this year, I'm not part of the Hungarian DPA, they received 125 emails, sent out 113 responses, 4 of which are in progress, and 8 requests fell outside the scope of what advice they could give. So that's been broadly successful. And the topics of inquiries were a huge range. Most of them were to do with GDPR compliance and other. And then you had almost equally a range of video surveillance, employees' data, data subject rights, the legal base of data processing, keeping a data protection register, the scope of the GDPR, and the DPO, etc. So this was a broad range of inquiries which suggests that SMEs all have different questions about different topics. And actually, I'm next going to talk about the biggest GDPR myths that we found that SMEs believed. And who's here, like by show of hands, from an SME or because they're advising an SME? Okay, so a fair few. So maybe this will help you. I hope so. So the biggest myths, that data protection or the GDPR didn't apply to them because certain SMEs didn't think that they were holding personal data or processing personal data, that you always need consent of the data subject to process this personal data. This notion of consent is king, which isn't always correct. As you perhaps know, there are a lot of different legal bases for processing personal data under the GDPR. That they're not handling sensitive data because they're not in the health industry. Sensitive data, special categories of data entails a lot more different sorts of data than beyond just health data. That the GDPR is a settled issue, it's all a done thing, rather than this kind of living instrument through interpretation by courts and the EDPB and other bodies, or national DPAs, member state implementation into national law. So it's certainly not a settled issue. It's consistently being clarified how exactly SMEs should apply it. And that data protection is about one singular issue. For example, CCTV, you saw that as one of the main questions, data access requests, and nothing else. But it's clearly not a one-time thing. It's not a one-issue thing. It certainly won't just be massive fines for massive companies. You've seen data protection authorities start to fine already ages ago SMEs. So it is an issue, and these aren't myths. And to go more into examples of the inquiries that the hotline received, which might be applicable if you are an SME or advising one, or if you're just interested in what sort of issues the GDPR has raised. The main question, are SMEs subject to the GDPR? Yes, if they process personal data. And there are some extra criteria. And then, does the processing of the client's telephone numbers qualify as data processing? Because that's a very common thing that SMEs do. Yes, because it concerns business or professional activity. It doesn't fall within the exemptions. Is it considered data processing when I publish my telephone number on my webpage or Facebook profile and I'm thus called by my possible clients? No, because that's not the processing of personal data of other natural persons. Yeah.
A quick comment to the first one.
Yes.
The exemption criteria for Article 30.
Yeah.
I think the conclusion for the vast majority of DPAs is that they are not exempt.
Exactly. Yeah, that should be written more nuanced. I'm actually going to expand upon that, but that should say in certain situations, but indeed you're right. So is a company subject to the GDPR when processing a small amount of personal data? Yes, because it is still personal data in itself, so it still applies. Is a company subject to the GDPR when one contacts a company, so a non-natural person with a direct marketing offer? No, because data subjects are natural persons, and personal data is related to an identified or identifiable natural person. Am I or my activity as an SME subject to the GDPR even when I process no personal data, but I do have employees? Yes, because employee data is almost always personal data. May consent be obtained from the data subject electronically? Yes, it doesn't necessarily need to be verbally or handwritten with a signature. It just needs to be unambiguous, informed, etc., opt-in consent. Is consent provided by a minor valid? This is one of the sections that different member states implemented differently, the age of a minor, and the provisions on the capacity and parental custody and guardianship, as well as the incapacity or limited capacity of adults. The provisions on capacity and custodianship are in that act of Hungarian data protection law, the civil code, but also in similar acts in other member states. So you have to defer to different regulations to see whether that consent is valid or not, or whether that needs to be done on behalf of the child by someone else. What is the difference between the provision of information under these different articles under the GDPR, so pertaining to data subjects? This Articles 13 and 14 are meant to ensure that the data subject receives a general and comprehensive picture of the processing, and the right of access under Article 15 has the express aim of the data subject receiving information on the specific processing of his or her personal data to establish and control the lawfulness of this processing. So it's more specific to that data subject. Then, when complying with the right to erasure under Article 17 of the GDPR, do personal data have to be erased from the backup files? In general, yes, and it should be done in technically feasible ways, so it should be traceable. If a natural person requests my enterprise to erase his or her personal data, and I thus erase it, oh, where did it go? Oh, I don't know what happened. Anyway, and I thus erase it from the records, how can I prove that I had received such a request and fulfilled it by keeping such a record? So, going to Article 30, perhaps an interesting part, and that the hotline received quite a few questions on. Must a data processor also maintain a data processing record? Yes, in certain circumstances, and this is where it's applicable. So those caveats that I mentioned, like if it might affect the rights of the data subject or if it's sensitive data processing. And this record shall be in writing, which includes electronic form. I intend to notify the data processing I carry out to the Data Protection Register, but I find no opportunity to do so on the website of the Data Protection Authority. So the GDPR itself doesn't provide for such a national data protection register to be maintained, and this is where, so the GDPR, but it does oblige each data controller and data processor to maintain this record, so they themselves must be maintaining this record without having to notify the authority thereof. So again, this is also slightly different between different member states. And does the GDPR, again, the classic question, provide for this exemption in view of SMEs? Yes, except that there are exceptions to the exemption. And I know the Hungarian Data Protection Authority, through a court case, clarified this. And then the general exception now is that SMEs are not exempt from Article 30 or keeping a record of their data processing in general. Almost done with these questions. Under what conditions may employees process the certificates of good conduct of employees? In the opinion of the Hungarian DPA, based on the GDPR and the National Privacy Act, they may process this on the basis of Article 6. So this is one of the legal bases for processing personal data. Article 6.1c, processing is necessary for the compliance with a legal obligation to which the controller is subject. So employers may only require their employees to show them their certificates of good conduct, so they may not make copies of them and own that themselves. And may an enterprise use GPS in its company cars? Yes, this falls within the legitimate interests legal basis for processing. So this is an indispensable condition of lawful data processing, and if an employer has a legitimate interest, which needs to be demonstrated in tracking, in using a tracking system to see where their employees are driving, for instance, then they may process this personal data. What next? I hope those questions were useful. If you'd like to discuss the kind of nuances of them with me later, please feel free to. What next? This was an exploratory phase for the Hungarian DPA, but also other DPAs. We interviewed 18 of them, and they have similar experiences with how SMEs do contact them. And unsurprisingly, it's the ones who are better aware and cognizant of the GDPR and how it should be implemented that actually do reach out to the DPAs. So in that sense, they're missing probably the SMEs who need some help with how to implement the GDPR. Yeah, this is a step in the right direction. If you're lost, reach out to your DPA, and hopefully the handbook within this project should be released soon and advertised. Thank you for your attention. If you have any questions, feel free to approach me. This PhD candidate from Hungary did most of the research, and this is the email for the Hungarian hotline. So feel free to also look at the project website, and you should be able to get some feedback from there. Thank you.
Hello, my name is Joan Antikal. I'm an external counsel in the area of data protection located in the United States. Since 2002 or so, I've had the honor of being a member of an international group of data protection authorities and sit on a team with them, which is chaired by the Berlin Data Protection Commissioner. So I'm here today to share some of my experiences in relation to SMEs in terms of their compliance and associated challenges. We've heard a little bit from the other speakers about the significance of SMEs in the EU. As you heard, there are about 22 million SME organizations, so about 99% of all EU businesses. The same holds true in the US. Also, 99% of the businesses are SMEs. There are about 30 million. And worldwide, there are about 500 million SMEs. So a very important part of the global economy in addition to the EU economy. Most SMEs collect personal data beyond the scope of their workforce. Primarily, they collect customer data. Typically, we don't think of customer data as the most sensitive type of data. For instance, it's not health data or, as we generally think of it, financial data. However, many times customer data does comprise certain sensitive data elements, for instance, credit card details or other payment information, and potentially profiling information or even tracking location through apps that are downloaded on the customer's devices. So there is some information that is sensitive that's collected by SMEs. We also heard that the GDPR specifically applies to SMEs, and there are a number of sections in the GDPR that, several sections that reference SMEs specifically. The main section is Recital 13, as you heard, which specifically references those types of organizations. And then Article 30, as we heard, contains really the only limited exception with respect to the record of processing activities. So all of the other articles apply to SMEs as they would to any other size organization that falls within the scope of the GDPR. We also heard that Articles 40 and 42 for reference to SMEs, and those sections apply to codes of conduct and certifications, and also say that special consideration has to be given to SMEs in relation to those attributes of the GDPR. There are several other sections of the GDPR that also have some leeway, some limited application or to SMEs. For instance, in terms of security, organizations need to align their security with the risk and type of data, and this may be different for SMEs because typically they have fewer systems holding that data than other organizations. And then in terms of enforcement, the supervisory authorities have the leeway, the ability to evaluate a number of factors that they can take into consideration in terms of imposing fines or other types of enforcement. And one factor, of course, is the size of the organization. But importantly, that's not the only factor. There are many others that need to be considered, such as the level of compliance of the organization and the good faith efforts of the organization to fulfill the GDPR obligations. As well as they'll also take into consideration, of course, the sensitivity of the data and the exposure and many other things. So SMEs certainly can't rely upon their size alone to hopefully avoid a fine or other enforcement under the GDPR, and it would be foolish of them to assume that they can. Now, in terms of SME compliance with the GDPR, Karen referred to a study that's published online under GDPR.eu, and that study was conducted in May of 2019, so 1 year after the GDPR took effect. The study involves 716 EU business leaders from just 4 EU member states. I think it was Ireland, the UK, Spain, and France. And of course, 716 businesses versus 22 million SMEs. You know, it's not really a representative sample, but nevertheless, in my view at least, the results were fairly accurate in terms of the experiences that I've had as well. So 50% of the responders, the business leaders of SMEs, said that their organizations were GDPR compliant. This is 1 year in. 86% agreed that it's very important to have GDPR compliance in place. They gave a number of reasons why they were or weren't interested in complying with the GDPR. For instance, it's the law. A big fine could bankrupt us. It's good for business to protect data. There can be grave consequences for non-compliance. We believe in the right to privacy, and our reputation would be dirt if we didn't comply. I like that one the best. The reasons for not complying included comments that they felt they were under the radar screen or not likely to be a target of enforcement of the GDPR by the relevant supervisory authorities. For instance, one business leader commented, "We are a small organization and have bigger fish to fry than the GDPR. More important things to do than comply with the main data protection law in the European Union." Another one said, "When you consider the misuse of data by the likes of Facebook, why would the regulators spend time levying fines on SMEs?" Of course, that's not accurate because they already have. Now, my experience with SMEs is parallel to the feedback from that survey. Some companies have been extremely compliant, and others not so much. The ones that are compliant have developed cross-functional teams. They have board support, interaction with their board, oversight of the projects. Full assessments took place, full implementation of the GDPR, ongoing assistance and auditing. And in addition, many of them decided to certify to the Privacy Shield at the same time. So about 70% of the companies that are in the Privacy Shield program right right now are SMEs. In terms of those that were not as interested in compliance, and by the way, none of them were my clients, I was asked to go and evaluate a vendor in Belgium, actually, on behalf of a multinational client, and was actually surprised because here in the EU, I expected to see, a relatively strong level of compliance, but they commented specifically that they just don't have the budget and did not have basic policies and procedures in place that we asked to see as part of our evaluation. Similarly, another multinational acquired a company in Belgium and several other EU affiliates, and they also did not have the data protection framework in place that you would expect. So there were a number of instances like that, and other vendors in other parts of the world, including India, that were receiving GDPR data also had similar deficiencies. Now, in terms of the general challenges for SMEs, there's a great deal of uncertainty, as I've seen and as you've heard today. There's a much higher learning curve for them because they generally don't have an established framework in place or didn't before the GDPR took place. They have fewer internal resources, and many of them, I found, went out and hired either an internal person to assist them with their GDPR or spent a lot of money on a law firm or multiple law firms or consultants to assist them with the GDPR. Lots of times these in-house so-called GDPR experts that they hired didn't have any data protection experience. Personally, my phone was ringing off the hook from headhunters, recruiters, and companies that wanted to pay, a fraction, I think less than I started as a first-year associate, to go in-house and take a job assisting a company with their GDPR compliance. So as you heard, they may not have gotten the best advice from those individuals. Now, one of the main areas of concern is in the IT area. The regulators look at the size of the IT group to see whether it's sufficient and also look at the expertise. I've had this a number of times with credit card breaches, and many times with SMEs, they don't have sufficient staff in the IT area and also may have outdated systems and equipment. In fact, in 2018, the Poneman Group, a very well-recognized survey group, noted that there was a 424% increase in cyber attacks against SMEs. Right now, about 43% of all cyber attacks are directed against SMEs, and the criminals know that these are relatively easy targets compared to many multinationals because they don't necessarily have the same infrastructure in place. Surprisingly, the same group, or actually it may have been Verizon, Verizon also prepares a report every year, determined that two-thirds of SMEs don't have disaster recovery and backup in place, which means they're an easy target for ransomware. And unfortunately, those that have experienced ransomware have had really unfavorable outcomes, even more so than fines by the DPAs. 60% of SMEs that have experienced ransomware or major cyber attacks have declared bankruptcy within 12 months. And these are US statistics. In Australia, unfortunately, the percentage is even higher, 80%. The estimate is that those SMEs had to pay $275,000 for the incident, and over $250,000, and these companies just didn't have the budget for that. So it's a lot less expensive to comply up front. There are a lot of challenges to compliance, and a lot of them have spent inordinate amounts of money on consultants performing tasks that really were unnecessary. As I said, there's a whole cottage industry that popped up for GDPR compliance, and that's really unfortunate. But these organizations do have to comply with the GDPR, and if they don't, they can unfortunately suffer some of these very negative consequences. Thank you.
Hello. I am Narciso Ballina Rodriguez, and I would like to start saying that I am not a lawyer. So I will offer a more technical perspective into the different challenges that SMEs have to face at the time of being GDPR compliant. And this is what has motivated me to actually say that GDPR is not so easy. So I am here representing the Smooth project, which is a Horizon 2020 project that has a quite multidisciplinary team of partners, which actually includes from research institutions focused on cybersecurity as ours at India Networks, but also data protection agencies. We would like to actually take this opportunity to invite SMEs interested in participating in the pilots, and you should not be intimidated by the presence of DPAs. They will not take action against you if you are not compliant. So, okay, the GDPR actually started in May 25th, well, became effective in May 25th, right? And it has actually shaken the grounds of a lot of industries, and regardless of the size. And in addition to that, also our inboxes asking for consent. But what happened is that the GDPR demands significant data protection provisions for enterprises of any kind, including SMEs. And as we have seen in the panel before, and many of the panelists mentioned, SMEs typically do not have enough resources, not only technical, but also human resources to actually face the challenges that the GDPR actually imposes. And the problem is that basically this can actually put at risk many of the enterprises. And Joan actually mentioned it. I was actually here, you can see it in the slide. It can also affect the reputation of your company, right? If there is anything really significant or embarrassing in your company, maybe your customers will not trust you anymore. So I will focus on this specific item, which is like the different technical challenges to be faced, right? So specifically, I will be talking about those small and medium-sized enterprises with a digital presence. That means that they either have a website or they implement a mobile application, or sometimes they might even actually delegate, have a blog post or things like that, right? But the big challenge here is that many enterprises outsource the development of these products. And this is typically driven by economic factors, like who is going to be implementing my website in the most affordable way. And as I will show later, this has actually have some implications. The third issue is that many SMEs, they are not fully aware of the repercussions of not being in compliance, right? And in addition to that, they do not also have the right background to actually comprehend what is the actual extent of this. And the fourth one, which is what the Smooth project is trying to do, is actually around developing or some sort of actionable tools that SMEs can actually incorporate in their institutions to make sure that they are somehow complying with the different requirements. So, well, there's some formatting issues here. So basically, we ran a survey to figure out what are the different challenges faced by SMEs. And we managed to recruit around 100 SMEs of various types and sizes, as you can see on the right side. The reason why you see the two numbers is just to make sure that you get it. It's not, there is some issue with the PowerPoint here. I don't know what's going on. And as you can see, many of them, around 58% of them, they are digital businesses. That means that they have an online website, or probably they even have an e-commerce portal in which they can actually sell their own products. So when we ask them more specific information about what kind of procedures they follow, we can actually identify that around 65% of them do not get only personal data from their customers directly, but also from third parties. And this is actually concerning if we take a look at the second row, in which we can see that only 18% of the SMEs that we interview are actually making use of informed consent. That means that they're processing a lot of personal data and collecting personal data, oftentimes without the actual informed consent of the user. Then the third one is somehow related to the lack of awareness, right? 76% of them do not know that they're actually processing categories of data that are actually protected. That could be health records or health information, or for instance, I don't know, imagine that you're a application developer doing some dating app, maybe the sexual orientation of the user, right? The fourth one, actually, John mentioned it. Around 41% do not actually have a backup of the personal data. And only 35% of them apply some basic security measures to their institutions. That could be either an intrusion detection system to identify data breaches, or some basic training of the different employees about how to use different password mechanisms in a more secure and effective way. But to me, the most interesting questions are these two that you can see in this slide. 76% of them use databases which are hosted in cloud services. And this is concerning if we take into account as well the economic factors of many decisions taken by enterprises. Oftentimes, what is free is not really free. So that can actually come at a severe cost in terms of privacy for the different customers of their enterprises, or maybe you will eventually get some ransomware that can actually put you in a quite difficult situation. But anyway, as you can see, 88% of the enterprises say and acknowledge that they own a website, and 53% of them even have a mobile application version, which is actually I would say my area of expertise, trying to identify privacy risks on mobile applications. So how we actually can contextualize all these findings? Well, based on empirical evidence that has been produced by the cybersecurity research community, we can actually see that even websites and mobile applications of any kind, even developed by big corporations with billions of US dollars of income every year, they are not actually in compliance. And this actually extends to certain applications which are supposed to have some additional, let's say, privacy considerations. So for instance, we did a study of the 8,000 applications published in Google Play which are directed at children, and 59% of them are not actually complying with the FTC COPPA rule, which is what regulates the privacy of the children in the US. The requirements of the COPPA are actually very similar to those in the GDPR regarding children's privacy. As I said before, the risks of externalizing the infrastructure that you use in your enterprise are actually high. And you should make sure as well that when you're using a third-party email provider or a third-party storage provider, you should actually make sure that those are actually in compliance with the GDPR. The big issue, in my opinion, is also the lack of control when they are actually externalizing the development of the software that they do. So one of the big risks is the integration of third-party components. Imagine that you have a e-commerce site in which you are selling your products, and you really want to, for instance, measure how efficient is your platform, so you integrate an analytics service in your website. This is actually quite difficult to really integrate from a GDPR perspective, because many of the SDK providers that are available today are actually very data-driven and very data-hungry, let me say. So it's important to actually understand that what you're integrating in your products is really in compliance. And finally, John also mentioned that they have very poor secure security measures and protocols in place, right? But what happens is that in the end, the SME is liable for their actions. So this is what we're trying to do with the Smooth platform, which is kind of like more focused on microenterprises, because we kind of consider that they are more vulnerable. And what would they can do? Well, the first one is actually changing the mentality. They need to understand that protecting privacy of the customers is really important. And they should also verify that when they're taking advice from external services, actually that was mentioned already in the panel, you should make sure that they really understand what they are doing. For instance, many certification authorities that are in the market today, they do not, for instance, go in depth in terms of what is the actual behavior of the website. They only basically check what you're reporting to them about your privacy policy, right? So there's often that kind of inconsistency between what the actual website or the mobile application is doing in practice with what they actually report in the privacy policy. And those certification agencies basically stick to what is actually facing the user, or the interface with the user. But this is actually a quite challenge from a research perspective, because it's very difficult to map policies or legal policies into heuristics that a machine can actually understand and apply on top of the software to really see whether something constitutes a violation of the regulation or not. Also, this is, at least in the case of Spain, there might be agencies, like this is the case of the Cryptological Center in Spain, who kind of like offer support to enterprises to implement and secure mechanisms, like to detect intrusions, or actually to implement security mechanisms to avoid those cases. So with the Smooth, we are still in the process of integrating out of and phasing out of the challenges that we realized as we developed the project that were not initially considered, because we really want to make it really easy to use and actionable in the way that an SME can get a report that they can actually understand and then apply to their own businesses. But it also has to be cross-sector, and it has to be also affordable. So what we're trying to cover are different parts of the digital presence of the, different parts of the digital components or modules that a company might have, like how they are storing the data, what is the structure of the database, how is the website on the mobile application they're doing, how they're actually collecting personal data and uploading it, and where is this data actually going. And as you can imagine, we are finding out of challenges, not only in terms of languages, because we are, for instance, trying to automatize the analysis of the privacy policy. So there might be different challenges because of the complex nature of legal and ambiguous nature of legal text. And additionally, also because of the languages that the SMEs are actually targeting for their customers. So basically, as I would like to take, as I said, this opportunity to invite SMEs to participate in our pilots. That will help us to improve as well and identify limitations. And in exchange, you will get that kind of report in which you can identify where you are having some ground for improvement, or where you're actually doing it right? And I will finish with that. Okay, thank you very much.
Thank you so much. Thank you to all the panelists. And I'm very sorry that everyone had so much to say that we don't have a lot of time for questions. Yeah, I would just like to see if there are questions in the room, so please raise your hands. Okay, there are a couple. And we can at least do one round of questions, and then if you have further questions, we can perhaps discuss also during the break.
Hello, my name is Bruno Bioni from Data Privacy Brazil and PhD candidate at University of São Paulo. As far I know, GDPR's regulatory rationality is based on risk-based approach. So what defines if a legal obligation is going to be more intense or not is not only the size of the data controller or data processor, but mainly if the data processing activity is riskier. For instance, the legal obligation to point out a data protection officer, to carry on a data protection impact assessment, or even the records of processing. So at the end of the day, there are a plenty of SMEs or even startups that have data processing activities that are going to be considered riskier. So at the end of the day, what is the asymmetry of the information between those SMEs and the big tech companies? Because the GDPR or even other data protection legal frameworks are going to be like a barrier for them. So are there some possible solutions?
Let's take another question, and then, because there was one just there.
So multiple people have mentioned the sort of risks of inconsistent or inappropriate advice or sort of getting with untrusted experts, is there any recommendations in terms of how to assess that someone who's offering support, or if you're looking for a company to give some of that, you know, consulting expertise, how do you know that you've found the right company or the right person and aren't being misled?
Any other questions for this round? No? Okay. Then, yeah, who would like to take the first? Okay, so you want to go ahead?
Yeah.
Perfect.
So with regard to the first question, that's exactly right. The risk or the sensitivity of the data is an important element in terms of the risk to the SME and their exposure. If they are collecting sensitive data, if it's a financial organization collecting financial information or health data or other sensitive information, and they have a breach, then most likely the breach will have to be reported, because again, there's more risk to the individual, and that's the test under the GDPR and most other statutes worldwide. So those organizations really need to step up and make sure that their compliance is stronger, and also to have the IT infrastructure in place. If they're not collecting sensitive data, then the framework, you know, it needs to be proportionate to the risk associated with the data, as you pointed out. In terms of the second question and evaluating both in-house and external assistance, the best thing that I can say is, you know, something is better than nothing. They took attorneys most of the time, or paralegals, to work in-house. They had limited budgets, so they thought, okay, well, you know, at least they can study the GDPR and learn. And they, again, were, you know, offering very, very little in terms of the hourly wages based upon, you know, the amount of budget that they had. Ask for references, even ask to see, you know, templates of documents or things like that that they've created for other organizations. Ask for a proposal and a budget. My approach is to try to create self-sufficiency within the organization so that you can continually reduce your reliance on outside counsel, have your own templates and forms and so forth. And then also internally, lots of times you'll see one part of a company ask for a contract or something, then another part ask for something else, and they're just wasting their budget that way by paying for the same thing over and over again, and it's really non-value added. Whereas if you had an in-house library of forms and things like that, you know, it works much better. So use your resources in a way that creates the most value for the organization, and ask for references, or go online and look at the real expertise of the individuals that you're choosing from.
Thank you. Anyone else wants to add? Okay, Karen.
Yes, in terms of the asymmetry and the risk, I would just concur exactly with what Joan has said. Also, just from an anecdotal perspective, the vast majority of feedback we get are from SMEs for whom data processing is not the core of their business. So I would say that there is also, conversely, those that aren't at risk are actually often over-complying with the GDPR. So there's an information exercise there to be had as well. In terms of how to avoid cowboys, we would say go to your DPA, and if your DPA doesn't provide any guidance, then go to one of the better DPAs first and foremost. Try to avoid exactly paying external counsel if you can. And obviously when Smooth is up and running, that will be our first go-to for all our all micros.
Thanks a lot. Are there any other questions at this moment? You would like to add something?
I would like to add something to the second question. So, for instance, also when they come to you, I had experience of the DPO that we hire for our research institute, and I was happily surprised by the depth of the knowledge of the two people that came. So one of them was a lawyer and the other one was a computer scientist. So that kind of helped you to know that to a certain degree they're going to have a deep dive into the different parts of your business and the different data processing and collection that it's gonna take place, right? Actually, they had like different interviews with different like human resources, what kind of telling them what kind of challenges they were more specific. And for us, because for instance, we are running internet measurements and we're crawling websites and stuff like that, and they were kind of asking like, where do you store the data? Who has the access to the data? And so forth. So basically, you can get a sense of how complete they're gonna be as well. But I agree that in case of doubt, go to your DPA.
Okay, thank you. Yeah, there's a question over here.
Yes, my name is Victoria. I have helped over 500 companies in Spain and South America, SMEs. But I think when it really comes down to proper compliance, SMEs don't want to take the time and the effort to really comply. So if you get them to do a lot of homework so they can produce their own templates and record their own processes, at the end of the day, they want to hire somebody that will give them a copy-paste thing and don't spend any time. That's my experience. And I keep struggling. I've worked with the Smooth platform. I've done a meeting for 30 companies, expats, and I think 3 were interested. For free. I mean, I didn't even charge. I just called them up and I helped them out. I explained how it works. They don't really value it, I think. So if you really want to do it, it will cost you a lot of time, a lot of effort, maybe not a lot of money. But how many are willing to really do that?
Okay. Anyone else in the room with a question?
Can I comment on that? Sure. So one of the factors that I've found that encourage SMEs is a business relationship or a partnership where the multinational or another partner says you need to have this compliance in place or we won't use you to provide these services to us. And then they are often, rushing to get everything in place right away. So that's a big factor to encourage them. And the other factor is, it's really a cost of doing business. If you don't have proper data protection in place these days, you're going nowhere. Your reputation is dirt, as one of the business leaders said. And some of them don't realize that yet, but you can also use data protection as a competitive advantage in order to sell your services to multinationals as well. Let them know we have this in place, and other vendors in our category don't.
Okay, Narsau.
I would say not only SMEs have the intention of making relationships with international companies, but in that case, I think that this is up to the point in which customers might start reporting this to the DPAs, right? Once the fines will come, I think many will actually start changing their behavior. And I am honestly one of those arrogant customers who typically ask, hey, why are you asking my email? So things like that can actually, once the culture of our culture actually and perception of the privacy issues of giving away personal data changes, many SMEs will actually have to adapt.
Can I just say that I think it's a really important point about value, and at the moment it's just seen as a drudge if they know about it at all, and they can't see the value of complying. So I think there's a big exercise that we need to carry out there.
Well, I think it's time to close this panel also in view of the coffee break that we already used a little bit for this Q&A. So I would like to thank all of you in the room for your attention and for listening to us. And I would like to invite you for a round of applause to the panelists who thank you very much. They've provided great expertise, and looking forward to continuing the conversation also during the breaks.